Hello, my name is Miles Florick. I chose to talk about content moderation and the NetChoice LLC versus Paxton court case. This case centers around the legal issues that come about when discussing how content is moderated and the impacts of First Amendment rights when doing so. I'll be discussing the background of this case and what the important aspects are. I will be analyzing and answering my research questions, discussing my findings, and how those findings came to be. Looking at the background of NetChoice LLC versus Paxton includes Texas House Bill 20. This is what the entire case is centered around. Texas House Bill 20 relates to the censorship of digital expression on social media platforms. This is argued that social media companies are more likely to censor viewpoints that they do not agree with. More specifically, it wishes to target prevention of political viewpoint censorship. Section 230 of the Communications Decency Act is brought into play as well. The goal of Section 230 is to protect social media companies from being liable for what their users post. An example of this would be if a user posts statements that are considered libelous or defamatory. The platform those are posted on are not liable or responsible for it. Specific elements challenged in Texas House Bill 20 are Section 2 and Section 7. Section 2 pertains to how social media companies go about moderating content and the steps taken to do so. The social media companies against this bill say that Section 2 violates the First Amendment and the platform's editorial discretion, compelling them to promote and leave up content that would otherwise violate their terms of service. Section 7 of Texas House Bill 20 would prohibit how social media companies censor content. The argument that social media companies are using falls back to their editorial discretion and their right to remove or restrict content. Lastly, the common carrier doctrine is put into play. The common carrier doctrine that applies to businesses providing essential services to the public, requiring them to serve all customers equally without discrimination. This is being used to determine if the state of Texas can perceive social media companies as common carriers, leading to some arguments being made unable to be used due to the nature of common carrier laws. Taking all of this into account, I will be asking the questions, is content moderation a violation of the First Amendment, and what is the impact of content moderation on an individual's freedom of speech? Leading into the findings, the courts found that in regards to Section 7 and editorial discretion, online platforms do not have the same editorial discretion as newspapers like NetChoice have made the arguments for. Because of this, they do not have the ability to claim First Amendment rights. The court stated that, quote, even if editorial discretion is a protected right, the platforms fail to exercise it because they disclaim the legal responsibility for content that traditionally adheres to editorial discretion, and they fail to perform the pre-publication selection and presentation that editorial discretion entails, end quote. When analyzing the application of intermediate scrutiny to Section 7, the court found it to be a content-neutral regulation. The platforms contested this, calling Section 7 a content-based regulation, saying it specifies certain online platforms, specifies platforms that are regulated by a certain size, permits certain censorship and not other, and targets the platforms due to their specific disagreement with the style of censorship. The court, however, dismissed these arguments, stating that the regulation of a specific medium does not raise concerns as content-based regulation, and there was insufficient evidence to suggest that the Texas legislature targeted specific platforms. Looking at Section 2, the court found that the disclosure requirements in Section 2 were not unduly burdensome, rejecting the arguments made by the social media companies. The ruling comes from a previous Supreme Court case of Zotter versus Office of Disciplinary Counsel of Supreme Court of Ohio. In that case, the court found that the states can require, quote, purely factual and uncontroversial information, end quote. The court found that the regulation in Texas House Bill 20 imposed minimal burden that many of the platforms already perform. Moving to the common carrier doctrine, the courts invoked the common carrier doctrine to rule that the non-discrimination requirements for social media are consistent with First Amendment protections. The court confirmed their ruling that social media companies fit the category of a communication firm stated in the common carrier doctrine because they, quote, hold themselves out to serve the public without individualized bargaining, end quote. The platforms argued against this decision, stating that, quote, they do not serve the public equally because they only served those who agreed to their terms of service, end quote, and they are, quote, not generally open to the public because they discriminate against certain views and forms of expression through their content moderation, end quote. However, the courts decided that the state can still impose common carrier obligations to communication firms that require terms of service when that same terms of service is offered to all potential users. Now looking into Section 230, the courts used the First Amendment doctrine to understand how Section 230 can be used in this case. In using this doctrine, they found that the regulations survived the intermediate scrutiny test that is applied to content-neutral rules. The courts concluded that the platform's censorship cannot be considered their protected speech. This ruling comes from the idea that the statute would create a broad immunity for social media companies by the companies stating that they are not related as the publisher or speaker of what is posted. Even with Section 230 allowing online platforms to retain immunity when removing content they deem objectionable, they are still, quote, not like publishers even when they engage in censorship, end quote. Furthermore, the courts found that the common carrier doctrine helped further empower the Texas legislature to prevent online platforms from discriminating against users' viewpoints in the state of Texas. The court ruled that Texas House Bill 20 does not violate the First Amendment. The statute in question is held to regulate platform conduct rather than platform speech. The case being strengthened by its ability to survive the intermediate scrutiny test and being empowered by the common carrier doctrine. The distinguishment of social media editorial discretion and newspaper editorial discretion come into play as the court states social media companies do not have the same editorial discretion as newspapers, citing Section 230 as it does not protect social media platform censorship of user content. From the evidence shown, we can answer the question of how an individual's freedom of speech is affected by content moderation. Content moderation does impact an individual's freedom of speech by leaving them afraid of being censored by posting something that social media companies deem unfit. With Texas House Bill 20, individuals' freedom of speech is able to be expressed the same amount or more freely, with social media companies less able to moderate content they do not seem fit. Texas is now being able to see social media companies as common carriers, and the platform's arguments against it saying they do discriminate based off of viewpoint leads to the understanding that companies have less of an ability to discriminately moderate content based on viewpoint. The overall question of if content moderation is a violation of the First Amendment still remains. Based on the findings, content moderation is not a violation of the First Amendment. This is only found if social media companies moderate content based on their terms of service and not based off of viewpoint. In this case, the social media companies did state that they do discriminate against certain users and forms of expression based on users' viewpoints. So in this case, it would be a violation of the First Amendment. Here are my sources, and thank you for listening. Have a good day.